Submission time frame not. Okay, we've dealt with that. Irrevocability of bid offer. I've talked about the situation of if there's bonds, if there's insurance, if there's something that has to come in after the fact, such as the MBE submission within 10 days after notification of award, etc. And if this stuff comes in or it doesn't come in, if the vendor finds out, for instance, they cannot get a performance bond, and a performance bond is due 10 days after notification, such that it isn't a matter of waiting another day or so to get it. They just say, we've been turned down by everybody, can't get it, so that you cannot award to that vendor. What do? And that depends on this situation. First of all, if it's sealed proposals and you have not notified anybody that they have lost yet, which we typically recommend that until you have a vendor that you've not only notified that they've won, but they've submitted all their required documents and they've signed the contract, we generally say you do that before you tell anybody else they've lost. Well, since no one else knows they didn't win until you tell them they didn't win, once you cannot award to the one vendor, you simply go to the next one in line, give them the same opportunity to give everything, get it all signed, sealed, and delivery, and then they won and the other people didn't, and the first vendor already knows that they were recommended, but now they can't get the award because they can't satisfy the requirements. So they're not going to squawk because they took themselves out of the running. If you have a bid, though, and you've opened the bids, so everyone knows when the bids were due and when the bid opening was and who supposedly was low bidder, etc. And then this vendor has to provide additional documents and doesn't sign the contract. And I think we went through the Fujitsu exercise on the third day. Was it Monday or the previous time, whatever, we talked about Fujitsu not signing the contract for public safety because public safety didn't get them to sign before they went to the Board of Public Works. And then Fujitsu decided they didn't want to honor it because public safety wouldn't sign their contract and all kind of different stuff. And so in that situation, they went to the number 2 vendor, but everything was already known. So the issue here is the period of irrevocability. This is the period listed in the solicitation when bidders or offerers cannot withdraw their bid or proposal. Now, they can withdraw before the submission due date. They can always withdraw a bid or proposal, but after the submission due date, they're required to identify the duration that their bid or proposal is irrevocable. And they identify that because we put it in the specifications. And the second line there, the state has the right to accept a bid or offer during this period, and the bid or offer must then sign the contract or be subject to sanctions. This period is usually 90 days for sealed bid procurements, but it could be 60, 120, etc. It could be 30, it could be 50, it could be whatever time we put on there. But if you look at the regulations, the default, unless you give a, a different time frame, is 90 days. For sealed proposals, again, if you look at the regulations, it uses 90 as the standard default for any situation, but we typically say if you're doing sealed proposals, make it 120, but you can easily make it sometimes shorter, but more particularly longer, even for sealed proposals. And what that means is the period of irrevocability can be important. If a selected recommended vendor is unable to provide required forms, insurance, MBE forms, etc., and it is necessary to try to award to another vendor in lieu of the originally selected one, as not mentioned on the slides on insurance because they've been taken out to put in another class, as long as the period of irrevocability has not expired, it is permissible to offer the award to the next vendor in line for the award. In other words, if it was 120 days and we offered someone to a contractor at 100 days, and at the 110th day they couldn't provide the information so that we cannot award to them, we still have 10 days before the other vendor's offer expires. So we have the authority to go to those vendors, the next vendor in line, and offer them the contract. If the time frame will have expired, then it's not quite certain whether you can or whether you can't. You're going to have to go to your lawyer and discuss it. What are you shaking your head about? It depends on whether the vendor, well, I'm going to kind of explain that. When I say go to the attorney, what's going to come into play is the factor of whether the next vendor in line wants the contract award or doesn't. Now, usually, it's kind of, you think it's a no-brainer that, of course, they're going to want the award. And if they've participated to this point, they probably will. And so, even if the period of irrevocability has expired, if they want to do it and you want to do it with the approval of your assistant AG, you can go to the next vendor in line and just have them sign the contract, etc. If they don't for some reason, let's say they have just gotten another contract in the interim, and they now have the capacity to do both contracts, they may not want the state contract anymore. And if the period of irrevocability has passed, all they have to do is not agree, and we can't force them. If it's within the period of irrevocability, we can enforce them. And if they don't, then we can use that in future procurements, etc., as an issue of responsibility. So this is not going to be a situation that comes up frequently, but it does have some significance. So you just should be conscious of the time frame that you put into your solicitations. If the period of irrevocability has expired, it may be necessary to do a re-procurement or find other means to obtain a vendor to do the required work, and that depends upon the circumstances. So just something to think about. MBE goal. Obviously, you're supposed to decide whether to establish an MBE goal, and if you do, whether to also establish one or two of the sub-goals that you are permitted to establish. And if you establish a goal, you have to say what the goal is, what the overall goal is, and if you do sub-goals, what the sub-goals are. The goals and all necessary instructions and forms must be included in the specifications. And there will be a class someday in the future on everything about MBE that you, what is that, wanted to ask but were afraid to, or something like that. Outreach and methods of distribution. Agencies are required to post notice on eMaryland Marketplace for any procurement expected to exceed $15,000, that competitive procurement. But eMaryland Marketplace should not be the sole means of providing notice of a procurement opportunity. Identify notification channels besides eMaryland Marketplace. In your planning, you should decide what your outreach is going to be. Publications, professional organizations, trade groups, internet search, yellow pages, and yellow pages do exist still. Identify vendors to be directly solicited. We have said this in the Procure class. You should not just rely upon eMaryland Marketplace to get the word out, particularly if what you're seeking is like a niche area that you have reason to believe that your vendors are not on eMaryland Marketplace. And I think, and I'm going to look to see if other people can enlighten me, that on eMaryland Marketplace, everything has to be by codes. And if you identify the code that you want a notice to go to, I think you can access the vendors for that code. Is that correct? I see one shaking of yes. So what it will pay you to do is to look at the codes, figure out which ones apply to your procurement, find out which vendors are registered under those codes, which means those are the vendors that are going to receive your notice through eMaryland Marketplace. And if you're aware of vendors that do this work that don't show up there, send to them in addition to eMaryland Marketplace.
They do have to register on eMaryland.
To get an award. They have to be registered to receive an award, not to submit a bid or proposal. Unless you're going through DGS, and DGS, the way they have bids submitted is through eMaryland Marketplace. So obviously they have to be registered to be able to submit in that situation.
Yeah, that's what we do.
And that's what you do. For commodities, for maintenance, if you're going through DGS, they're going to be registered or else. And one other thing I will say, even if you see your vendor listed on eMaryland Marketplace, or vendors that you expect to be able to do this, there's nothing that says that at the point that you put a notice out there on eMaryland Marketplace, they're going to be looking at that point in time to see it. So it may still make sense to directly notify them, to have two ways to try to get their attention and get them to open something up and look at it. So you got to do email to marketplace, but do more in addition to that. And don't forget to provide a copy of the solicitation to GOMA, Governor's Office of Minority Affairs. You are required to do that. So even if you're doing everything else, you will send a copy to the Office of Minority Affairs, and that's typically just by an email. And do they anymore just get it off email and marketplace, or do they still require an email? GOMA, do we still send them emails? Yes, you send GOMA an email that includes your specifications. Yes?
When the solicitation is released on e-Maryland, don't they automatically get a copy of it?
I do not know if GOMA automatically gets a copy from e-Maryland Marketplace. I don't know.
GOMA would have to be listed under that particular commodity code, and I don't think GOMA is.
The unofficial answer is that GOMA likely is not listed under that commodity code because they don't provide any services, and so the suspicion is they do not get it simply through e-Maryland Marketplace, so you better send them an email. Because if you don't notify GOMA, potentially you have a voidable contract that you cannot award unless the Board of Public Works approves it. Because that is a requirement in law and regulation. And if you violate law and regulation, only the Board of Public Works can allow you to make an award that has violated law or regulation. So notify GOMA.
So it's still 15,000, right?
Yeah, 15,000.
I thought it went down.
It was 10, it went up. It used to be that you, well, it used to be 25,000, excuse me. The notification of GOMA used to be at 25,000.
No, but the publishing on e-Maryland Market.
Used to be above 25,000.
Now
When,
it's 15.
when they changed, there were 3 categories of small procurements. Category 1, Category 2, Category 3. Category 1 was 1 to 5,000. I'm trying to remember this because once something changes, I kind of substitute the new one for the old one.
Earlier it was 2,500.
1 to 5, 5 to 10, 10 to 25, I think was what it was. Category 1 was 1 to 5. Category 2 was
Category 1 was 2,500. Category 2
2,500?
10,000. Then 25.
All right, 1 to 2,500 was 1, 2,500 to 10,000 was 2,
Yeah.
and 10 to 25,000 was 3. And the requirement was that for Category 3, you must give 3 working days notice to vendors to respond. There was no requirement to put an email on a marketplace, but you still had to wait 3 days, 3 working days before you could make an award. And you still had to have some kind of a published notice available by means generally available to the business community. And when there was some interest about a year or so ago to make some changes, that GOMA was trying to get, I think, everything over 10,000 put on email to marketplace, bless you again, so that there would be more direct notification to the minority community. And so they were okay with the 0 to 5,000 for Category 1 and the 5 to 10 for Category 2, but they wanted Category 3 to stay at 10 and put on email to marketplace. And so the back and forth negotiating was that they would allow Category 2 to go up to 15,000 as long as at that point everything went on email to marketplace. So you got an extra $5,000 of leeway before you had to do a notification, but then the notification became email and marketplace. I forget these things. Okay, let's see. Is it okay for electronic submissions? And that is the thing, we did distribute that Monday, right? The electronic procurement authorized, 3 pages or 2 pages or something like that? All right, so that's what goes with this. Vendors can submit bids, proposals electronically only if the solicitation specifically allows this. If the specific specifications do not allow it, they are not permitted to submit electronically by email or whatever. Vendors can also file protests electronically only if the solicitation specifically authorizes protests to be so filed. And not coincidentally, if you read that 1.5-page document on electronic procurements authorized, the one thing we specifically say we will not accept electronically is protests. We don't want to make it easy for vendors to just send an email protest. You got to put it in writing, and it's got to come through the mail or hand delivery, and we have to receive it, or it's not a protest. It's not timely. So, submitting a bid via email on Marketplace is a form of electronic submission. So, a size being submitted via email on Marketplace or for small or emergency procurements, the recommendation is that electronic submissions not be permitted. That is the suggestion. So you have to identify in your specifications whether you will allow it. And we typically do for small procurements, because the difficulty, if you're getting something by email and Marketplace, it is set up that it will keep bids secure unopened until the due time and date. And then it will allow it to be opened by DGS. But for most other entities, you have no means to keep an electronic submission sealed until the due time. Once it comes in, it comes in. And you can say, I didn't open it, but you may not be able to prove that, or you may not know enough not to open it until you open it to see what it is to know that you shouldn't have opened it. And so if you say don't send it by electronic means, they can't. And in particular for sealed proposals, and the thing that I am most concerned about, usually a proposal is very voluminous. 20 pages, 30 pages, 50 pages. I would rather the vendor pay for printing out 5, 7, 8 copies than me print out 8 copies. So yes, you give me the hard copies of those proposals. So that's why we say typically you should not allow it electronically. If you're going through email and Marketplace, that is an electronic submission, and the very fact it says that is the exclusive means it's a permitted means. So, and we've given you the 2 slides, and what you cannot see, I guess, is what's on the handout. Is that correct? Because I'm seeing it's invisible. This is the electronic clause. Yes, you can read electronic procurements authorized, and you can't read anything after that. So if you want to know what's on there, the handout that you got on Monday is what is on those 3 slides that you can't read. If a procuring agency is also a primary procurement unit, and there are 10 primary procurement units, they were identified in the overview, and you remember them vividly, I'm sure. And the 4 of us in this room from DBM are part of a primary procurement unit, and the rest of you aren't. Because of the 10, 5 of them are identified right there: DBM, MDOT, DGS, DOIT, and Department of Public Safety. The other 5 are the University of Maryland, Morgan State, the Treasurer's Office, St. Mary's College, and the Port Commission. So none of you are any of those 5, and only 4 of us are among the first 5. Those are the only ones that can use that exact same language, simply changing their name for DBM. For DHMH, for environment, you can use probably 95% of that with some other changes, and you need to go to your attorney so that you make sure what the other changes are. And I don't even know specifically what changes they have to make, because what I was told is have their attorney talk to my attorney. So if you want to use it, have your attorney talk to my attorney. And they have to figure out who each other is. If a procuring agent, okay, we've said that. There, see? It's right there. It's easy to pick it out. 712, yes. Oh, I know what I did. In that version, I put in the 20 slides, so I'm off by 20. So I would be looking at it at 732. That's why I can't find it at 712, because I printed out the full expanded version. Okay, see, that's what you can't read. And you can all just read that right off the screen, I'm sure. But it's the exact same thing on what you got Monday. So 2, 3, there it is. All right, moving on. Required fee for procurement documents. It is permissible to require vendors to pay a fee or deposit to obtain solicitation documents. However, this is rarely done anymore except for voluminous blueprints, etc. And if you want to do this, you must put it in your specifications. So they know that they have to do this. But I can't remember the last time I have ever seen a document where a vendor is charged to get it, especially since anymore, what this used to be done for was to cover the cost of printing. We don't print them anymore. We put them out on the internet. We send them by email. They print it anyway. So even though it's permissible, we don't do it for the most part. So, but if you would do it, it should be in the specs. Pre-proposal conferences and site visits. Again, we're talking about what goes in specifications. These need to be described in terms of when, where, this type of thing. The date, the time, the location, how you register to attend, that type of stuff. It is recommended that all but the simplest procurements have a pre-bid or pre-proposal conference. We've talked about this a couple times. This is one of the primary means to get discussion from vendors, questions and answers, for us to get the meeting of the minds relative to what we want and what vendors understand that we want and what they're offering, etc. A site visit should be offered if it is determined unlikely that a valid response can be submitted without seeing where the work must be done. We don't usually mandate a site visit. We don't usually even have a site visit. But if you have a circumstance where they have to repair, let's say, a installed chiller or something like that, or some kind of installed equipment, where they can't really give you a price until they go out and see what they have to do and where they have to do it and things like that, you can say you have to come and you have to look at this to give a bid. All right, I'm saying that you can say that. But then I will point to the fourth bullet up there, right here. In fact, if you read COMAR talking about pre-bid conferences, it says the pre-bid conferences are mandatory if you establish an MBE goal. So if you establish an MBE goal, according to COMAR Title 21, I forget the exact section, that it says that vendors are required to attend the pre-bid conference for the purposes of trying to maximize the ability to make linkages with MBEs, etc. And so initially, at one time we said pre-bid conferences and site visits are mandatory. And then upon the recommendation of the attorneys, we stopped saying they're mandatory. We said they're encouraged but not mandatory. And then something else, we had someone else who said, but they are mandatory in regulation, so we need to say they're mandatory. And then in response to that, the AGs pulled out this decision from March 3rd of 1987, opinion of the Attorney General. And the opinion of the Attorney General is interpreted as being essentially the same as law, because they're saying what the law says. So that means that's what you follow. And in this particular opinion, the Office of the Attorney General stated that a bid or proposal from a vendor should not be rejected solely because the bid or offer failed to attend a pre-bid proposal conference. That shall not be the only reason that they are rejected. In other words, that's why for years they said we could not make the pre-bid or pre-proposal conference attendance mandatory. And we started saying that it cannot be made mandatory, even though COMAR Title 21 says it can be if there's an MBE goal. And so we went to them and said, all right, what's the answer? And they said, this is our opinion and we're sticking to it. That cannot be the only reason for rejection. If you have another reason for rejection, if they don't give you a responsive bid, if they're not responsible, if their proposal is not reasonably susceptible, you can reject them for that. But you cannot reject them solely because they did or did not attend a pre-bid conference. And then we said, well, what about site visits? And the answer was the same logic applies, that you have to make a determination if you think they have to go in and see the premises to be able to give a valid bid. And when they didn't do that and they gave you a bid, you have to decide whether that bid is valid, whether it's responsive or whether the vendor is responsible. And you can make your determination the vendor is not responsible, and you make that because in questioning them, because you can determine issues of responsibility after the due date, in questioning them, you have determined they apparently don't understand some aspects they need to understand, and you can reject them as being not responsible because you've done follow-up and you've decided they're not responsible, which not doing the site visit certainly might have been a contributing factor, but it wasn't the only factor. If they didn't make the site visit, for instance, an incumbent should know what they've been repairing. And an incumbent may not attend a site visit, and you may think their bid is perfectly fine because they know what they're supposed to be doing. They didn't do a site visit, you're not going to reject them. So you have to do it based upon the merits of the situation. Okay, nice and confused. Isn't procurement fun?
Oh, yeah.
No? I agree. It is not fun. It's work. Oh, sometimes it's funny, but there's funny that's funny, and there's funny that's pathetic funny. Submission to include, information to include on the submission envelope. And I think we touched on this a little bit earlier, but we're going to touch on it again. The name and address of the submitting vendor and maybe a general phone number or email address. The title of the procurement and the due date and time, the fact the envelope contains a bid or proposal. And I want to emphasize that they have this information in case there's a reason you have to contact them. If you've made a change in the specifications and you made that after they've already submitted something, let's say 3 days before a due date you get a bid or proposal, and the scenario Gary said where you get a question 2 days before the due date, and you answer that question 1 day before the due date, and what do you do now with that proposal you already have, because the vendor obviously has not considered the answer to the question that you've now answered. You want to be able to contact them and say, do you want it back? Do you want to stick with what you have? What do you want? And to do that, you have to know who it's from and preferably have a contact person to contact. So that's why we recommend you do that. If there is to be a separate, yes?
And what if vendor didn't provide any address or any name on the envelope?
If they didn't provide any information for you to be able to do that, then my default answer will be you go to your assistant AG and see if they can tell you that under the circumstances that it's permissible for you to, bless you again, open the envelope to find out. But you would only do that after consulting with your assistant AG. And the answer that you might get, and I frankly don't know what answer you're going to get, but the answer you might get is, nope, they were told to put that information on the outside. If you can't contact them, then they live or die by whatever happens when you do open it after the due date. I don't know. If there is to be a separate technical and financial submission, what to include in each? What to include in each? I guess that's redundant. If there are to be separate submissions, what to include in each if there are separate submissions. So I think the last part of that is redundant and can be eliminated. Do you want an unbound submission? Do you want electronic CD? These are things, typically we will say we want an original that is unbound, if this is a proposal. We want an unbound original, we want X number of copies, and we want a CD of what we're getting hard copy, so that we have the ability to, if necessary, copy more of them, either from the CD or from the original, etc. But we put that in our specifications. Number of copies.
We also require PIA.
You also require the PIA information, which means a redacted copy of a proposal with anything the vendor deems to be confidential to be excluded. And I don't know if you ever had an issue with a vendor not providing it, and if so, what you did with that. And that started when I was here, and when I went to DBM, I tried to do that down there, and the first time I did, my attorney at that time said, we can't say that. And I said, well, why can't we say that they have to provide a redacted copy? Because we can't. Well, how can DHMH say it, and it was okay with the assistant AGs up at DHMH, and I come down here and it's not okay with you? Because it's not okay with me. And you're not at DHMH anymore. Okay.
That's the glory of the state.
Yes. All right, I know. Yes, ma'am.
Well, that's the glory of the AAG system. And Joel's absolutely right. We've had different interpretations here also. To the extent that the PIA copy by some AAGs is believed to be the responsibility of the procurement office before, if somebody makes an inquiry that they want a copy of a solicitation, then it's up to us to redact what they can and cannot have. Other AGs have taken the position that they get the opportunity to take out what they believe is subject to the PIA, which is usually resumes, company confidential information that's not available by public means, and line item pricing, not final pricing, but line item pricing. So we do give them the opportunity to do that. And we're requesting now that the PIAs also come in electronically, for what it's worth.
After you put an electronic procurement authorized clause into your documents. According to our AGs, that is now necessary for you to even allow that. And going back to that issue, vendors almost inevitably take out more than we think that they are permitted to take out. And so, yes, the procurement officer needs to make a final review to see whether stuff that the vendor has asked to be confidential must still be divulged by the vendor. So the procurement officer still does have to look at it, and if doesn't agree with everything the vendor said to be confidential, you need to tell them to get real. Now, if you're comfortable with what they have given you for the redaction, then yeah, you just release it. But my experience is they will put more that they want excluded than you will want them to exclude. Let's see, and you should identify the requirements for the transmittal letter, i.e. the transmittal letter is a letter that transmits the bidder proposal, typically a proposal, and so you want it to be signed by someone in authority that can commit the offer to the commitments of the proposal, including the price, etc., and to identify who should be communicated with in the future, things of this nature. And something I may or may not have put in these is you want to identify how addendums will be dealt with. Damages. Insurance, bonds, etc. are means to try to protect the state from lack of performance, from property damage, personal injury, etc. Even without these means or any other described protection mechanism, there is still the availability of damages. So insurance, bonds, things of this nature are supposed to help protect the state, but even if you don't require these types of protections, there is still under common law the concept of damages. Damages means the harm inflicted on one party to a contract by the other party, assuming it is just two parties to a contract, due to some form of contract non-performance. In this class, it means the harm to the state due to a contractor's actions or inactions, whether deliberate, by negligence, etc. The purpose of damage is to make the injured party whole. This is the concept, make the injured party whole. And that is the same as if the other party would have performed, not more than. Penalty is designed to exact revenge. We're not trying to get revenge, we're trying to just get what we would have gotten to begin with. That's why penalties are not permitted and damages are. This typically is done through the payment of money. Sometimes, although I've never had this in a contract, but theoretically it could be through what's called specific performance, that money is not an adequate substitute for doing what the contract called for. They have to do what was required, but since I've never had it and can't think of a circumstance where it would be the case, it always comes down to money. Yes?
It may be a small point, but our slide start with 723.
$723 versus $719.
718. Your first slide on down and start at 718.
You'll get the missing slides next time.
So there's one missing slide?
18, 19, 20, 21, 22, 5.
There's 5 missing slides?
Yeah.
Okay. All right, I remember what happened. I added some slides and I told Gary to start from 723 because I'd already added those in my version, not remembering that the first version you printed out didn't pick up the, all right, I understand what's going on. So there's 5 missing slides. You can,
Pay attention.
here's what they say.
Take note.
When you get the whole thing, this is it. That is 978 slides. Okay, damages means the harm inflicted on one party due to a contract by the other party due to some form of contract non-performance. In this class, it means what I just said, the harm to the state due to a contractor's actions or inactions, whether deliberate by negligence. The purpose of damages is to make the inter-party whole. This typically is done through paying money. Specific performance, we already said all that. Damages construed to be a penalty are not enforceable. If it is construed that what you're saying is damages is actually penalty, no court, the Board of Contract Appeals, will enforce that provision because penalties are not permitted in contracts. A penalty seeks to punish the violating party for the wrongdoing. Damages make the wrong party whole, allows the wrong party to have the value it would have had if the offering party had done what the contract required it to do. Penalties are permitted for what is known as torts, not permitted for contracts, which are not torts. Penalties are not enforceable in contracts. So you've heard me say this. And I think on the first day I told the little story of Scott Livingston and me sitting in the front row, and he hits me, which is assault, which is a criminal action, and then he flings the eraser and accidentally hits me, which is negligence, which is a tort. In both cases, the one there would be criminal sanctions, the other I could have sued for actual and punitive damages as a penalty, and he said contracts are not either of these. Unfortunately, he didn't do anything for me for the contract. Requirements can't be written into contracts that are designed to punish a contractor for violating a provision of a contract. Even if a vendor doesn't object to a provision when it signs the contract, it can still object if the contract seeks to invoke the provision. And we deal with this a lot in the perform class. You keep hearing me say that over and over, because obviously what you put in your specifications in advance impact what you can do when you actually have a contract being performed. And seeing in the perform class situations of the harm or the problems that can develop because of what you didn't put in advance in the planning stage means the next time you do it, you should put it in the planning stage. So they're just, you can't escape one versus the other. So even if a vendor doesn't object now, it can object later if you ever try to invoke it. The vendor can claim the provision is really a penalty regardless of whether it is called that and refuse to pay the amount specified in the provision. And if we, because they don't pay it, we deduct the money because we hold the money, so we deduct it because we think we should not pay it, then they file a claim against us. And we force it to file a claim. If the decision of the appeals board or a court is that a provision is a penalty, it is not enforceable. And we talked about the merchant of Venice and the pound of flesh, so that same concept. It's the same as if the provision didn't exist at all. So if it's found to be a penalty, you could have saved yourself the time and effort to have written it because it's the same as if you didn't write it to begin with. So a ploy of vendors when the state seeks to invoke certain provisions is to claim the provision as a penalty. this can result in legal proceedings over whether a provision is a penalty versus damages. Damages are available under contract law. So you still don't have this one?
We got this one.
This one, so this is the start of the class. Now you should pay attention. It's important enough we actually gave you a copy of it. Without the mention of damages in a state contract, they are still available if they are proven. You do not have to have any provision in your contract that says we have the right to collect damages, because it is a facet of contract law that damages are collectible to the extent they are provable. But you have to prove them. You have to go out and you have to provide evidence, initially probably to the contractor. Here's what we believe is the value of what we should collect from you or deduct from you because you have not performed. And if they dispute that and it goes to a claim, then we'll have to prove to the Board of Contract Appeals that that was the value of them not performing. And if they appeal a decision by the Board of Contract Appeals, we will have to go to court to prove that this was the value of what they didn't perform. All without it being in the contract at all mentioning any of this. There is no problem if a contractor does not dispute, and I guess that's what I said. However, the contractor does dispute after either that it is liable for damages or the amount of the damages the state claims it is owed, there needs to be some legal proceeding to determine which party is correct, the state or the contractor, or a combination. And this frequently happens. Yes, there are damages, but now we will establish what the damages are. And the damages may be less than what the state claimed, or it might be more. Well, I don't think it'll ever be more than what the state claimed, because the vendor is contesting what the state did claim. So the court's not going to come back and say, we think it should be more. So this is what could happen with damages. For state contracts, issues of damages are initially determined by the Maryland State Board of Contract Appeals. Decisions by the appeal board may be appealed to the courts in this sequence: circuit court, and there's a circuit court for each jurisdiction in the state. Then there is the Court of Special Appeals. There's one Court of Special Appeal, and beyond that there is the Court of Appeals, and there's only one Court of Appeals. And it's rare for them to ever go beyond the Board of Contract Appeals to circuit court. And I can only think of, as far as I can remember, only one procurement-related instance that has gone beyond the circuit court, even to the Court of Special Appeals. But that's what's possible. Damages are a two-edged sword. A contractor can seek damages against the state. If we did something that caused them to have harm because we didn't perform, they can seek damages against us as well. Whereas they are a type of damages, whereas they are a type of safeguard for the state, they are a type of liability to vendors, getting back to this issue of risk. At the beginning of the class, various facets of risk were explored. It was stated that people and vendors try to avoid excessive risk. Being liable for damages is a risk factor for vendors. Most state contracts have a requirement for the contractor to indemnify the state and hold it harmless. And many of you can probably remember there is a clause that says indemnify and hold harmless. And it says the contractor is to indemnify the state and hold it harmless for any expenses due to their performance under this contract, et cetera, which means the vendor is saying they will not go after us and they will not seek anything from us if there's a claim. They will take care of it on their own. This is not a mandatory clause. There is nothing that requires this to be in state contracts, but it almost always is. But we're going to tell you that you have some leeway as to whether you put this in or put in some variation of this. Even if there are required levels of insurance bonds, et cetera, there can still be an indemnification clause, which kicks in above the level of the bonds or the insurance. Insurance bonds, et cetera, help assure that when justified, damages liability will be paid. Because it's one thing to have a judgment of damages, it's another thing to collect on it. And sometimes the collecting is harder than getting the judgment to begin with. Even without these, or in addition to the levels required by a particular state contract, damages are available to the extent they can be proven in a legal proceeding, that a judgment in the state's favor can be collected from the contractor, and collected from a contractor, but a contractor may declare bankruptcy to try to avoid paying it, or the state may need to go to court for an additional time to try to invoke some kind of court order for the vendor to pay under the damages that a prior court order has said they were liable to pay. So it can get into a sticky situation. Due to the inclusion of an indemnity clause, vendors may decide not to compete for certain state contracts. If they perceive that the risk of having damages invoked against them is too high, just like any perceived high level of risk, including insurance levels or bonding that are perceived to be too high, can also cause vendors not to compete. Anything that's too much means vendors are either going to not go after it or charge more. Vendors not competing for state contracts means the state must do what it needs itself, do without the subject of the intended contract, or pay more to get the vendors to do it. So that's what happens if we have excessive requirements. We are never supposed to have excessive requirements, always just right requirements. Remember that. You heard it from me first. Never too much, never too little, always just right. And you have the simple job of figuring out what just right is. A term frequently used by vendors is that the state imposes unlimited liability. Has anyone ever heard this term from a vendor? But the state has unlimited liability. And if you go through your document and you say, where did I say those words, unlimited liability? And you will not find it anywhere in the state document. But if you had well, let me go through this. Unlimited liability simply means there is no cap or limitation on the liability of a vendor, contractor. Unlimited liability isn't used in state contracts, but indemnify and hold harmless usually is. And the translation of indemnify and hold harmless means whatever the damage is, the vendor has to pay. So their terminology for indemnify and hold harmless is unlimited liability. So now you know where the term comes from if you've heard it before, and if you never heard it from before, you've heard it now. Yes?
Does that basically mean that if they break it, they got to fix it?
Yeah. Means whatever damage they cause, and damage can take two forms. Actual damage, and it could be the situation they come in to fix something, and it could be fixing something that you think is going to cost $100. And in the process of fixing that, they break something that cost $1,000. Well, now they have to pay the $1,000 of what they damaged, plus still fix what they were supposed to fix before. So rather than making maybe $10 or $15 profit off a $100 job, they now have to pay $1,000. So how long can they stay in business by paying out money rather than making money? That's the issue for vendors. And so from the vendor standpoint, they don't want to be liable for their own actions. And that's the thing I always have issues with, for their own actions. And I have trouble in insulating them from things that they cause. And from my standpoint, if they cause it, they should pay for it. So let's see. Based upon the underlying premise of damages and that what is provable is collectible. Even if there is no indemnity clause or no clause mentioning damages at all, the damages that are provable are collectible, doctrine still applies. Decisions must be made in the planning stage regarding damages liability, whether to include insurance and or bonds, whether to have an indemnity hold harmless clause, since it isn't mandatory, what performance or acceptance standards that you will put in there to know whether a vendor has performed, and you have the right to cap liability. Just as you have the right to put in the indemnify and hold harmless, you have the right to cap this thing that you add to your contracts if you decide it is appropriate to do so. So whether to cap liability must be measured against the perceived effect on competition, including the ability of smaller minority firms to compete, which ultimately translates into price. Just as we went through this exercise on do you make minimum quantity guarantees? And the first reaction is no. Why should I guarantee anything? But then when you put in a little example that where it may pay you to make a minimum guarantee, you make a dollars and cents decision of whether you think it's in the best interest of the state If you think it's in the best interest of the state, you do it. In a particular procurement situation, if because of the comments from vendors, and in particular their comments like, if you don't cap this, I'm not going to respond. If you have a lot of vendors saying, you got to do this or else I won't bid, maybe the proper thing to do is to put a cap on liability. If no one's squawking, don't do it. If there is squawking, you have to make a decision. A decision should be made whether to cap the potential liability risk to vendors. A specific clause limiting liability is needed for that to occur. If you say nothing, if you have not one word in your specifications about the existence or non-existence of damages, by common law, the damages exist. You have the ability to collect what you can prove. The only way to cap that is to specifically put a statement in your solicitation that damages are capped at, and then you have to say what the cap is. There are two typical ways to cap damages liability, and that is by one, establishing liquidated damages, and two, by actually putting a finite limitation on the potential amount of damages, a limitation on liability. So that's the two ways we put a cap. We've talked a little bit about liquidated damages before, and let's see, limited liability. I don't think we'll get to liquidated damages today, which will probably be fortunate, and you'll be glad to start that first thing in the morning on November 5th. It's an exciting thing to go over. Yes, indeed. But limited liability, very simply, is a limitation on liability specifically stated in the solicitation contract. Typical liability limitations. When you do it, when you determine it is appropriate, here's what you typically will do. Number one, you will say that we will not go beyond the bonds or the insurance that we have mandated. In other words, we're not going to go after any more that we will be able to go to a third party to collect from. If it's $100,000 insurance, if it's $500,000, we'll accept that as your maximum exposure, Mr. or Mrs. Contractor. The value, so that's one possibility, and I don't think we typically do that. Another possibility is we say the limitation will be the total value of payments made by the state to the contractor. So they won't be in the situation of having to pay us more than we pay them. At the most, it's a break-even proposition. What we paid them, they have to pay back. That's a possibility. Don't recommend that, but it's a possibility. The third, and I guess I should say this another way, there's two ways to look at that, total payments or total value of the contract. And sometimes the only way to know the value is by the payments, but other times you have an established contract value, and it can be the value of the contract period, not just what the vendor has been paid to a particular point in time. So I probably should add that in the future. The other possibility is a multiple of total payments by the state to the contractor. 2 times, 3 times. If any of you are aware of the first TSP procurement, Technical Services Procurement for Information Technology, that occurred in 2002, which was the precursor to the CATS 1, which was then the precursor to the CATS 2. But the TSP procurement, before that time, we had never, at least at DBM, and for the most part, as far as we know, the state, had never put a cap on liability. Well, now I'll take that back. When we did the year 2000 procurement in 1997 for vendors to cure all the state's computers so that they wouldn't be affected by the year 2000, we put a cap on liability on that because the vendors said there's no way they're going to touch any computer if they're liable for anything they don't catch in thousands of lines of computer code. And so the only way to get any vendor to even undertake the project was to hold them harmless for anything other than contract value. So we did that in the year 2000 procurement, and then we did it in the first TSP in 2002. And in 2002, we had a limitation of 10 times the value of any task order, because that was a task order-based contract. And I can remember the highly scientific way in which the 10-time liability was stated, because this was an important issue of the governor's chief of staff, who at that time was Major Riddick, and We had a meeting in Major Riddick's office, and I was there, and my lawyer was there, and our IT director was there, and there were a couple other people there, and Major Riddick wanted this procurement to be gotten out on the street and gotten out promptly. And the last sticking point was whether we were going to cap liability. And so from the vendor community, you were hearing that you got to cap liability. And the AG's office was saying, don't cap liability. The state has too much risk if you don't cap. And I can remember the situation where my assistant AG told the story, and it wasn't a story, it was an occurrence, where the construction of the light rail, when it was a single rail, and they had concrete ties, and the concrete ties were supposed to last, I don't know, 20 years or something like that. But only 2 or 3 years after they were installed, they started deteriorating, so that MTA had to end up tearing up all the light rails for some miles in duration and replace the ties and then put the rails back. And so they ended up paying, I think, 7 times more to replace the rails than they put for these concrete ties to be installed to begin with. So that was the story of why you don't put a limitation on liability. And Major Riddick listened to that and said, well, okay, well, taking that into consideration, can you throw out a multiple that you would, what I'm hearing from the vendors is they want a cap. They're saying, just as long as they're a cap, they're not saying what the cap needs to be. So what do you think is a sufficient cap to afford proper protection to the state? And my assistant AG thought for a few minutes and said, 6 times actual contract value. And Major Riddick said, make it 10. Just to be extra safe, 10 times liability, issue it. And that was the scientific way in which we established the liability. And when you're talking about a cap on liability, that's all you have to do. Put the cap in there. However you determine it, that's how you do it, which is different from liquidated damages that we're going to get into on the 5th. So that's just a little story about how it happened for the first time in 2002. And let me just see. All right. I'll go through 4 slides yet, and then we'll be gone. Any limitation of liability for a contractor means there is no longer unlimited liability, but some vendors may still may not participate in any procurement when the liability is a multiple of the value of the contract, or if there are not limitations, further limitations. What vendors, even if you do a multiple or a cap of liability, they often come back and want you to exclude from that cap indirect, consequential damages or the ability of third parties to seek damages against the vendor. And what we recommend is that if you do a multiple of total payments under the contract, there may be a likelihood the contractor's actions or inaction could cause a higher level of loss to the state than when the contractor, than what the contractor could be paid. So that's the whole issue that we said there about why there's an issue of multiple. And what I want to point out is even if the vendor comes to you and wants further limitations, such as consequential, indirect, the ability of third party to file suit, you should say no. That your only limitation is going to be the multiple that you say, and you will not make further limitations to that. But we also say that you should make counter things, limitations of what are not subject to the limitation, i.e. we're not going to give you a cap on liability for things such as if you do a patent or copyright infringement, you should know whether you're using something that someone else has patented or has copyrighted, so we're not going to allow you to get away with just a 2 or 3 times contract value for that. If you destroy millions of records, we're not going to allow you to get away with just a one-time cap for something like that. You must recreate. Or if it is resulting from malicious actions or fraud, the cap doesn't apply. So those are examples of how you can not have the limitation that you have. Exclusions from a liability cap increase the potential liability of a vendor beyond the stated multiple of contract values. So it means further protection to the state. Usually there should not be further limitations on the liability of a contractor than the value or multiple of the value of the contract. We talked about the indirect, consequential, etc. Don't agree to those because that means we're taking away from our cap. We're giving them actually more protection from what might happen, so we shouldn't do that. The liability, the limitation cap should be the only protection afforded vendors. We should reject the request for multiple or additional caps or exclusion from the limits of liability, and that's where we will start on the 5th. And it's 4 o'clock. How about that?